Moving on to an update on the American Law Institute, ALI, and the restatement of the Law Third of Torts. And with it, we have a wonderful leader for this panel as well, Judge Timothy Tymkovich, who is on the U.S. Court of Appeals for the 10th Circuit, and also we're very grateful for his service as a member of the Judicial Education Program Judicial Advisory Board. So with that, I turn it over to Judge Tymkovich.
Thank you, Donald, and welcome back, everybody. Again, I'm Judge Tim Tymkovich from the 10th Circuit. I sit in Denver, Colorado, and it's great to be here in Arlington for these programs. They've always been so valuable, and an opportunity to moderate a panel last year as well, and I'm really glad to be back. Well, we're going to talk about the restatement and the American Law Institute for this panel. I've been a member of the ALI for 20 plus years, even before I became a judge in 2003. Thus, I've had a chance to watch the organization grow and evolve through its more recent iteration. Since I've joined the ALI, it's gone through numerous new projects and leadership changes. I'm pleased that its current leader, its director, is Diane Wood, former chief judge of the 7th Circuit and a good friend of mine. And other judicial colleagues are also on the ALI board, including Jeff Sutton, the chief judge of the 6th Circuit, and Judge Allison Ide, who's a judge on my court. So there's significant judicial leadership within the organization, as well as broad-ranging leadership and participation among the legal profession. Since the ALI was formed in the 20s, it's developed into an influential voice in American law. This panel will discuss some of that history and the ALI's current project to update the law of torts. The ALI project is a large fan club, but also a few critics. I generally respect its scholarship and efforts to create a national reference point on many topics, especially the bread and butter areas of law such as torts and contracts. In fact, in my judicial career, I've cited the restatement over 50 times, much to my surprise when I did the research last week. And some of the new innovations have been particularly promising. I occasionally teach election law at the CU Law School in Boulder, and I really endorse the ALI's efforts to try to reach consensus on many issues on how we run elections and count ballots and contest results, one of the newer projects. But let's get to our discussion. Our 4 panelists are well described in the materials, and I'm excited to be on this panel and topic. First off will be Larry Stewart, star trial lawyer and former member of the ALI Counsel and Executive Committee. Next will be Chris Appel, counsel at Shook, Hardy & Bacon, and also an ALI member. Third will be Geoffrey Wyatt, a litigator at Kirkland's DC office with extensive experience in complex state and federal court matters. And finally, Professor Michael Green next to me, a professor at Washington U School of Law and co-reporter for the Restatement Third of Torts. So let's get started with Larry.
Thank you. Good morning. I was elected to the ALI in 1993. And when I joined, I was well aware, as probably all of you are, that restatements are accorded great reverence in the civil justice system. And even in the criminal, we do have a criminal restatement also. But I knew very little about the process by which restatements are created. And what I learned once I became a member was really amazing. It is a highly complex, multi-layered process where every single member of the ALI has the opportunity, if they want to be involved in the creation of a restatement. There are 4,000 members currently in the ALI, and it's a diverse mix of judges, academics, practitioners, public service lawyers, government lawyers that come from throughout the United States and bring a broad range of perspectives to the process. Restatements are, as you may know, unique legal documents. Unlike treatises and law reviews, which are only peer-reviewed by a handful of editors or reviewers, before they are published. As I noted, everybody in the ALI has an opportunity to be involved, and often for restatement projects, there will be more than a few hundred lawyers involved in the process of creating a restatement. Restatements are also different from legal opinions because judicial opinions, because judicial opinions are confined to the case in controversy, whereas restatements can examine in a comprehensive manner an entire subject or body of law. It is basically a common law process that is used in creating restatements that proceeds from precedent and then applies logic and reasoning to come up with the various black letter sections that are contained in a restatement. The ALI is not writing, when they're doing restatements, on a clean slate at all. They simply cannot make up the law that goes into a restatement. Restatements, as you may be aware, begin with somebody suggesting that a restatement is necessary. It can be anybody. It could be any person in this room. It's not confined to members of the ALI or the governance of ALI to come up with ideas. But once a suggestion is made, that goes to the program committee, which then examines it to see whether this is something that's viable and worthwhile for the ALI to expend its resources on. And if so, to determine what the scope and the content of what a restatement is that will cover. We've done all of the traditional areas of law, like torts and contracts and property, but we've also done a lot of other unique things like education law, election law, and principles of policing, for example. We have just launched a brand new project on the principles of AI civil liability. And the first episode of that, the first installment of that, is just been released, just a couple of weeks ago. If the program committee feels that this is something that's worthwhile undertaking, it makes a recommendation to the council. The council is sort of like the board of directors of the ALI. It consists of about 60 or 70 members who are elected from the membership because of their leadership or their expertise, and they basically decide issues of policy as far as the organization is concerned, but they spend most of their time on reviewing restatement proposals. If it is approved by the council, then reporters are selected, and then in addition to reporters, a group of advisors are selected to work with the reporters. Typically, this is about 60 to 70 people who are experts in the field. And in addition to the advisors, there are also on every project what is known as the Members Consultative Group, in which any interested member of the ALI can sign up for, and they can also then be personally involved in the development of the project. When Torts came along, Torts Third came along, we actually have a first and a second. The second was done in the 60s and the 70s. But by the 1990s, then Executive Director Jeff Hazard observed that there had been so much water under the bridge on torts in the intervening years that it was probably time to do an update and to re-examine torts. And unfortunately, torts had become such a broad project, such a vast area of law, that it couldn't be done in a single project. There was no William Prosser around to undertake the entire thing, so it was divided up. It decided it would be done in segments. As it turned out, ultimately there were 7 different segments involved, 7 different restatements involved in the Torts Third provision. Most of them have been finished. There's a couple that are in the last stages of it right now. And so they're flashing me a sign already, and I'm just partly through telling you how this works. But basically how it works is that reporters come up with a draft. The draft is sent to the revisers and the members consultative group. They talk face-to-face about it. They go through the project page by page, word by word, punctuation by punctuation. It then goes to the council. The council goes through it page by page, punctuation by punctuation. If it is approved at the council, it then goes to the annual membership meeting. Sometimes at the council, things are sent back for further examination. For example, one of the things that we're going to be talking about later this morning, medical monitoring, went back several times for reconsideration. But once the council approves it, it goes to the membership. And at the membership, any member can get up and speak. They can object to it. They can make a motion about why it should be changed in any particular way. And then a vote is taken. And it is only after that entire process, very time-consuming, because it usually takes, for a typical restatement, it will take somewhere between 5 to 7 years to produce a restatement. Some take as long as 10 years. Through that long, involved process, a consensus is reached. Very seldom is there controversy about provisions in the restatement, because the whole idea behind this laborious process is to come up with a consensus. And we have a couple of rules that apply in the membership meeting that try to aid that taking place. First of all, projects have to be debated on the merits. Personal attacks, those type of techniques are prohibited. We really don't have a problem with that at all. As a matter of fact, many people say that if Congress could debate issues the way the ALI debates issues, we'd really get something done in this country. And the other rule is that you have to leave your clients at the doorstep. While you will bring in your personal experiences and your personal things that you have developed over your lifetime, you don't come into the ALI meeting to act in service of your clients. We're seeking to get the very best possible outcome that we can as a result of the end of the day. So when it's all said and done, we end up with a restatement that is not the law. It is a statement of what the law could or should be in any given situation. And it only becomes law when you folks adopt it in one of your opinions. So that gives you a flavor of what is involved in a restatement and how they come about, and why I think, and many others think, that they're entitled to great weight in the process of adjudicating claims and issues between parties.
Thank you, Chris.
Great. Well, thank you, Larry, for that. That's an excellent distillation of what the ALI does, and hopefully it'll help inform what we're talking about so it doesn't sound too much like inside baseball. But I thought I would begin with something I often say when talking about the ALI, which is that the ALI is the most prestigious organization that would have me as a member. I've been a member for the better part of a decade and have been attending meetings much longer as a guest of my dear friend and recently departed colleague, Victor Schwartz, who was a 50-year life member. So my critiques or criticisms of the ALI, which are many, as I'll get into, are really coming from a place of tough love and a desire for the organization to self-correct before, in my view, it's frankly too late. And I'll try to explain what I mean by that. My fundamental concern, criticism, in a nutshell, is that the ALI, time and again, simply ignores its own standards when developing a restatement, with the result being that the ALI has effectively become standardless when it comes to restatements of the law, which, as Larry described, are the ALI's flagship work product that have been used to educate judges and lawyers for generations. Now, the ALI has some pretty unambiguous written standards for restatements. There's literally a manual for reporters who draft restatements that says restatements are designed to set forth, quote, clear formulations of common law as it presently stands or might appropriately be stated by a court. Reporters are directed to adhere to 4 principal elements in developing a restatement, which include instructions to ascertain the nature of the majority rule on a topic, ascertain trends in the law, choose the specific rule that fits best with the broader body of law and therefore leads to more coherence in the law, and ascertain the relative desirability of competing rules. Restatement provisions are also constrained by the need to find support in sources of law. And the ALI Style Manual expressly cautions that the ALI, as an unelected body, quote, has limited competence and no special authority to make major innovations in matters of public policy. Reporters are further instructed that recommended wild swings in law are inconsistent with the work of a restatement. Despite these clear instructions, though, the ALI has proposed some pretty wild swings in law that fully intend to make major innovations in matters of public policy. There is a growing list of examples where the ALI, at least in my view, makes no serious attempt to set forth a clear formulation of common law as it presently stands, and instead invents a legal rule for courts to adopt that does not reflect the common law of any jurisdiction. A decade ago, the namesake of this law school, Justice Scalia, observed this trend in a U.S. Supreme Court opinion, saying, quote, modern restatements are of questionable value and must be used with caution. Over time, the restatement's authors have abandoned the mission of describing the law and have chosen instead to set forth their aspirations of what the law ought to be. And Justice Scalia made these comments with respect to a provision of the Restatement Third of restitution and unjust enrichment. I would submit that instead of having this U.S. Supreme Court Justice rebuke serve as a wake-up call of sorts for the ALI to make a more concerted effort to adhere to the organization's standards, the exact opposite has occurred, where novel restatement provisions have increased in frequency over the past decade. A good case in point is the restatement of the law Consumer Contracts, which the ALI finalized and published just last year. This restatement proposes to restate contract law specific to agreements entered between a business and a consumer. But it does so where courts have not articulated a separate set of consumer contract rules that operate differently from the general law of contracts. In other words, this entire restatement resorts to reimagining what the common law ought to be. And as a result, most of this restatement's provisions do not reflect the law of any jurisdiction, and taken together, they propose to invent a new common law regime. And for example, this restatement includes a novel section on interpretation and construction of consumer contracts, which, if adopted by courts, would significantly change how contract terms are interpreted. The black letter rule includes a consumer expectations analysis combined with a preference for interpretations that operate against a business, and regardless of whether a contract's terms are unambiguous and objectively reasonable from the consumer's perspective. In this instance, the reporters actually objected to this provision on the basis it was not supported in existing law, but my co-panelist, Mr. Stewart, to his credit, he is a skilled advocate, made a successful motion to overrule them and include this the day this restatement obtained final approval. And what this means is that after 10 years of this project's development, the ALI membership saw this entirely new section with entirely or potentially sweeping implications exactly one time, discussed it for about 15 minutes or so, before adopting it as a black letter restatement rule. And I mention that because it underscores some of the ALI's deepening institutional concerns that I hope we can discuss. It's also worth noting that this restatement adopts a novel common law deceptive contract theory that basically just appropriates language directly out of consumer protection statutory law, And instead of relying on case law, for example, the restatement resorts to citing things like FTC policy statements to support the proposed rule. This restatement also adopts a novel and expansive view of unconscionability doctrine. It proposes courts abandon the parole evidence rule with respect to all consumer contracts. And it proposes that courts treat each of its novel provisions as mandatory rules that can't be contracted around, among other changes. And so while I believe that the consumer contracts restatement it may be the most egregious example of the ALI ignoring, frankly, its standards, it is by no means an isolated example, which brings us to the third restatement of torts, and specifically the miscellaneous provisions restatement. I believe my co-panelist, Mr. Wyatt, plans to discuss this restatement's treatment of medical monitoring, so I'm going to focus on an even more recent novel proposed rule, the miscellaneous provisions restatement's special rule on vicarious liability for sexual assault. This provision endorses the imposition of vicarious liability against an employer for a sexual assault perpetrated by an employee against a vulnerable third party. So just imagine you work at a daycare worker who sexually assaults not a coworker, but somebody else. If you did the recommended readings, one of them is a motion I submitted at the ALI's 2025 annual meeting in May, urging the membership to take no position on this issue and leave it to further case law development. The motion failed, but it underscores the same concerns I've talked about here about the ALI endorsing rules that plainly do not present a clear formulation of common law as it presently stands, and instead propose major innovations in matters of public policy. When this provision was first unveiled, the reporters, Professor Green being one of them, were candid that the proposed rule, quote, did not previously exist and is contrary to Hornbook law on vicarious liability. They explained that this provision, quote, breaks with traditional tort doctrine by permitting the imposition of vicarious liability where an employee commits a sexual assault with no motive to serve the employer's interests. So here you have a situation where the employee commits an intentional tort for self-gratification or some other purely self-serving interest that is presumably contrary to the employer's interests, and the employer is subject to vicarious liability, which is strict liability regardless of the employer's culpability. Subsequent drafts, at least in my view, were less candid about the rule's novelty, but still conceded that no jurisdiction adopts the proposed black letter rule. The restatement says this admittedly novel tort claim is based on a public policy desire to promote compensation against employers. Although it's worth noting that this focus ignores potentially adverse public policy implications, such as placing an incentive on employers in an effort to reduce their vicarious liability exposure from engaging with or providing services to vulnerable populations. And that's frankly one of the problems with endorsing an untested tort claim. Interestingly, one of the miscellaneous provisions restatement's reporters, co-reporter of Professor Green's, took the rare step of publicly dissenting from this provision's inclusion out of concern for, quote, concern for the legitimacy of the American Law Institute in the legal community to which it speaks. So you have a situation in which the ALI knew full well what it was doing in endorsing a rule it acknowledges no jurisdiction actually adopts, one with major public policy implications, and just kind of goes ahead anyway. And all of this goes back to my introductory tough love remark, because the ALI, at least in my view, is facing an impending credibility crisis. I think it is only a matter of time before a critical mass of judges recognize they cannot take modern restatements or treat modern restatements as a clear distillation of existing law without doing their own independent research, something that calls into question the very utility of a restatement. And I think the ALI needs to course correct on a variety of fronts that I'm happy to discuss, but I know my time is up, so I'll reserve that for the Q&A, I suppose. Thank you.
Thank you. We've set forth some interesting turf here. Let's move to Mr. Wyatt.
Thanks, Judge, and thanks, Chris and Larry, for those initial topics. And I'm going to stick with the miscellaneous provision, the compellingly titled miscellaneous provisions of the third restatement on torts. And I'll start with some classroom participation, but no worries, I'm not going to call anyone, just a survey. How many people have dealt with, either in practice or on the bench, a medical monitoring claim before? A couple, not many. What about vicarious liability for sexual assault? Okay, a few more, but still a minority. And so we are truly in the miscellaneous provisions of the third restatement here. And I think that highlights the risk that Chris is talking about or putting his finger on in his discussion of what's our assumption about what we're learning from the restatement when we come to it on a topic that we've never dealt with before. And I think in the old days, it would be safe to assume that this is a restatement of the law, not a reshaping of the law, which is to some extent what's going on in some of these provisions in the miscellaneous sections of the third restatement on torts, not because of some nefarious scheme, but because there's just not a lot of law out there in some of these areas, or if there is, it's all over the place. And so it's very hard to distill what the rule is or even should be, and I think it's very important to be mindful of that when approaching the restatement as a source of authority, or at least a source of influence on answering questions where there's no binding precedent in your jurisdiction, whether you're a judge or a practitioner. And so I think medical monitoring is a good example to use for this, because medical monitoring law is all over the place. There is no way to restate it in a way that does justice to all of the many different approaches that have been taken to that issue. But I do think, sort of sounding the same theme that Chris was sounding with respect to vicarious liability, I have issues with the way the third restatement has approached medical monitoring, because I think it describes itself as taking a middle path when in fact it adopts a minority approach and bucks the prevailing trend in the law. So I want to talk a little bit about what is medical monitoring, which seems like it might be helpful given the very few people who have dealt with it in practice before, and then talk about how, given the state of the law at a very high level, since I only have, is it 10 minutes? Are you going to play the music like at the Oscars? Don, that's a feature we should bring.
I'll play the music.
Yeah, okay, all right. So I'll try to keep it. I'll try to keep for the 20th anniversary. It seems perfect to add. Okay, so what is medical monitoring? It's basically a form of relief. It could be a cause of action, or it could be a remedy. It varies by jurisdiction. It has some implications for things like class certification, but we won't get too in the weeds on that. But some courts have described it as a freestanding cause of action of its own, so kind of like negligence, but its own thing. Others have said that it's either damages or it's an equitable remedy of some sort, but it has its own similar predicates that have to be established that are kind of like the elements of a cause of action. The third restatement doesn't take a position on that piece of it. It acknowledges that there's a division in approach and kind of moves on. Medical monitoring is being addressed for the first time in the third restatement because it did not exist at the time of the second restatement. It began to emerge in the 1980s in the context mostly of toxic tort cases, although also in some other contexts. The DC Circuit was the first court to recognize medical monitoring as a compensable expense. There was a plane crash. The plaintiffs alleged that they were at risk of increased risk of developing a neurological disorder, and the court recognized that as a viable cause of action. From there, it was adopted in a few other jurisdictions initially to deal with toxic tort cases. And the theory is that because some toxic exposures don't immediately cause illness but could do so in the future, individuals who are exposed but don't suffer a present injury may nevertheless have expenses down the road that, in fairness, the argument goes, should be borne by the defendant. Courts approving the remedy have offered kind of a number of reasons. One is for the early detection of disease and improving patient outcomes. One is that medical monitoring is cost effective. It may help plaintiffs avoid the need for more expensive medical treatment later if they don't catch it until the disease actually manifests in full. And courts have also reasoned that, sort of citing traditional tort principles, this will serve to deter against tortious behavior if there's liability for medical monitoring. So over the years, over the decades, courts and commentators have really struggled with whether any form of medical monitoring in the absence of present physical injury, and I'll just put a point on that because that's really the heart of what the third restatement's innovation is here. There are a number of jurisdictions that allow medical monitoring as a form of future medical expenses where the plaintiff is alleging that he or she has a physical injury. The innovation, both in the cases that have come before now and in the third restatement itself, is even absent present physical injury, would you be entitled to some form of damages based on the possibility that you would have develop an injury later? And the arguments in response to this are, number one, for 200 years, a basic tenet of tort law has been that you need present physical injury. This is the liability limiting principle. It's also a bright line principle. If you don't require physical injury, you sort of open the floodgates. The argument goes to what counts as possible future harm. You see a similar policy rationale in limiting liability for pure claims of emotional harm, which do exist in some jurisdictions, but are not as expansive as tort claims for physical harm. There's the possibility that imposing a medical monitoring remedy will punish defendants for conduct that did not actually and never does cause any injury. There's tension between the medical monitoring remedy and the economic loss rule, which generally holds that plaintiffs in tort can't recover for purely economic injury. There's an argument that medical monitoring awards could reduce recovery for individuals who do have presently or in future manifest concrete injuries, at least in the case of defendants with limited resources. There's a much broader pool, almost by definition, right, of people who would be eligible for medical monitoring than there is of plaintiffs who would actually manifest that injury later. And so the question is, do you spend that defendant's money now or save it for the future? And then there's public policy concerns. Should courts be involved in the administration of fundamentally medical operations like monitoring, especially when the disease or its treatments or its monitoring methods are cutting edge or emerging? So how have courts resolved these debates? Many jurisdictions, as I mentioned, recognize medical monitoring in some form, whether with present injury or without. If you aggregate the jurisdictions, you can find it most places. But there are several disagreements on core requirements, first and foremost of which is whether the plaintiff must suffer a present physical injury prior to having a viable claim for monitoring costs. Right now, present injury is not required in, depending on how you count them, roughly 12 to 16 states. The others either have rejected it or have not answered the question. There's several other splits as well. I talked about one at the beginning. Is it a standalone cause of action? Is it a remedy? Mostly important in terms of deciding the certifiability of these claims in class actions, because that's when you sort of get into the nitty-gritty of what's a common issue, what's not. It doesn't matter if it's liability versus damages or a remedy. There's sort of a watershed moment in the history of these debates. In 1997, the Supreme Court decided, as a matter of federal common law, that there is no cause of action for medical monitoring in the absence of present physical injury in Metro North Commuter Railroad versus Buckley. And since then, the trend on that issue, the necessity of present physical injury, has been against it. Most state courts, not all, but most state courts that have weighed in on that issue, state courts of last resort since Buckley, have rejected it. And then there's other issues as well. There's questions about whether medical monitoring should be limited to toxic torts, right? Or if it should also apply more broadly to any sort of product liability context where there's a possibility of future harm, even in the absence of present harm. There's a question whether how you treat it under in a class situation, which is often the situation in which medical monitoring claims are asserted, right? Most people aren't going to bring a tort claim for $500 of monitoring charges. They're going to bring a tort claim for 10,000 people who need $500 of medical monitoring, or so they allege. And so then there's a question of, are the issues common or not, which turns in part on, is this injunctive relief? Are we parceling out damages on an individual basis for everybody who qualifies? Do we have to have them all go through medical tests to determine, and so on? And so that's another issue in which the courts are split. There's also a question whether it's a common law cause of action or whether it's a remedy. Can you also seek punitive damages based purely on a claim that I'm not injured yet, but I might be later? And then there's a claim splitting question. Do I forfeit my right to bring the personal injury claim later if I get the medical monitoring now? And some courts have looked at that and said, well, that seems like a bad trade. Why don't we solve the problem by just carving out from the collateral estoppel rule medical monitoring claims so that people can have the best of both worlds? But not all courts have done that. And there's good reasons not to do it, especially in terms of limiting liability and sort of going to the well twice for the same essential claim. So how does the restatement deal with this mess? And it is a mess. I mean, I practice in this space. I'm not on the ALI, but when the ALI came out and said, you know what, the middle road is going to be, let's have a cause of action for the absence of present injury, that sounded absolutely incorrect based on my experience. So I was surprised to read it. And here's sort of a couple of statements from the restatement that I think hedge the position a little bit, but not enough for my comfort. So it does recognize and endorse, as I just said, a medical monitoring remedy in the absence of present physical harm. It says in the comment that, quote, there's no clear trend, emphasis mine, either for or against acceptance. 1 minute, I'm gonna get there. I might go a little bit over, but I'm borrowing from Chris, who finished like a minute ago. We'll be all right. I won't belabor it. I think the word clear in that sentence, though, is doing a lot of work. The trend is definitely against it, and if you dig deeply into the restatement, 12 pages in on Westlaw, you find a quote to the U.S. District Court of Colorado, which is a fine court, I have no doubt, but just one court, saying, neither plaintiffs nor defendants are able to demonstrate an overwhelming surge of decisions that would indicate that there is a strong national trend one way or the other. That's a little bit different from describing what the trend in the law actually is, which is against the adoption of this kind of cause of action. The restatement also claims that there's broad agreement as to medical monitoring's core requirements in jurisdictions that recognize it, and there, two things are doing a lot of work. Core depends on the eye of the beholder, which elements of medical monitoring are core. There's disagreement, a lot of them. But also in jurisdictions that recognize it, leaving out the fact that that's only 12 or 16, depending on how you count. The middle course that the restatement claims to chart would be, if we take the median of the jurisdictions, no cause of action for medical monitoring at all in the absence of present physical injury. So I think it comes back to some of the themes that Chris was touching on a minute ago. What is the role of the restatement? Is it to restate the law, or is it to reshape it? And if it's the latter, perhaps that's justifiable in a space where there is no clear central majority approach. But I think we have to approach the restatement ourselves with that understanding in mind that it may no longer be restating the role, and it may not be entitled to any greater weight than a law review article or some other source that you would consider in the ordinary course of resolving issues like this one.
Thank you, Jeff. We'll finish up opening remarks with Professor Green, and this is really a rare opportunity to hear from a co-reporter of a restatement. So, Professor Green, thank you.
Thank you, Judge Tymkovich. I think Larry did a great job in his presentation and in his written materials explaining the American Law Institute, how it produces restatements of the law for which it has become known, and its more recent venture into principles of the law, such as the liability, AI liability, civil liability project. There's no case law out there to restate, so those reporters are trying to put together advice for the industry, which is desperate to understand what their potential liability might be. My 2 cents, which I fear may exhaust my budget for this session, is to emphasize what Larry said about the process of the ALI. It is extensive. It involves lots of different lawyers, judges, and academics in what it produces, and it goes over materials multiple times with lots of opportunity for comment. And let's see if we can get there. Yeah, this, for example, is a motion that was made by Chris and a couple of others in advance of an annual meeting to modify what the reporters, what the project was proposing. There's lots and lots of opportunity for input for those people who don't like it. My written contribution explaining the history of the third restatement of torts and the part titled miscellaneous provisions came to be. The most important point there is a meeting in August of 2007 by leaders of the ALI and by those who were involved in the restatement. The result, that was in Austin, Texas, and the result of that meeting was important. As a result of that, the decision was made that the third restatement of torts, when it was done, would completely replace the second restatement of torts. And the progress that's been made on it is such that almost all of that has been done. That is, third restatements that are out there often adopt what was in the second restatement, sometimes with modification, in light of the 60 years since it was published. And those third restatements are out there, if you will. Now, for reporters, we often sit up front at the podium, and we have members and advisors tell us what mistakes we've made. Chris and Larry have been very good at that through the years that we've restated. So now, turnabout is fair play. You may recall that Larry said there were 7 projects in the third restatement. Larry, I think there are 9, and I've listed them here. When the third restatement is done, there will be 9 volumes, subject specific. Okay. I was just at a meeting about artificial intelligence in Spain, and there was a lot of talk about deep fakes. So I decided to have some fun. We did a little bit of testing if you could detect a deep fake. I tried to convince LEC to give a Jaguar to whoever can get this correct. Tell me which of these volumes is a deep fake and which ones of them are real. There's 9 volumes up there. They reflect what at the end of the day will be the third restatement of torts. Are there any deep fakes? And if so, which ones? Unfortunately, we don't have an opportunity for you actually to submit.
Can I guess?
Sure. Chris?
All the ones on the bottom row are deep fakes.
He wins the Jaguar. The 5 on the bottom are projects that are in play, that are going, but have not yet been published. The 4 on the top are volumes that you can actually find in your library, or more importantly, on Westlaw or Lexis. Yeah, there's the revealing the deep fakes. It's amazing what ChatGPT 5.0 can do, even in the hands of somebody who doesn't understand it. The topics in the third restatement, this is a list of the leading topics in miscellaneous provisions, and it includes the ones that Jeff and Chris were talking about, but quite a number of others. What we did in miscellaneous provisions was necessitated by the way in which the third restatement was produced that involved specific projects. And back in 2019, Bill Powers and I were asked by the ALI to come up with a blueprint to end the third restatement, which had been going on since 1992. And we realized that if that commitment to replacing the second restatement in toto was to be met, we needed this miscellaneous provisions. That involves restating subjects that were I'm sorry, let me say this. These subjects were all new. They've all emerged since the second restatement, and if the restatement of torts was going to cover these new torts, needed to be addressed. Some subjects that we've done in miscellaneous provisions are to update subjects that were in the second restatement, but in light of the last 60 years. That's those 2. And then finally, we put into this miscellaneous provision subjects that should have been in the restatement of torts, but for various reasons never were. Can you imagine not having vicarious liability in a restatement of torts? Well, until this miscellaneous provisions in the third restatement, there wasn't such. Let me spend the 5 minutes I have left commenting on what restatements are, because I think there's a fair amount of misunderstanding. The name is not terribly conducive to what restatements are. A restatement is not merely a counting of jurisdictions' rules on a given tort, determining the majority rule, and then putting it into black letter. Sometimes there is no majority to be found. Medical monitoring is a case where there's no majority to be found because jurisdictions are evenly split on a particular issue. Sometimes there's no way to find a majority because there are multiple paths taken by different courts. Joint and several liability in the United States today has about a dozen different permutations that are reflected in different states. It would be impossible to speak about a majority. Sometimes there is no majority to be found because the law on the subject is a mess. It lacks coherency, and what a restatement can do is contribute to greater coherency. Sometimes a minority rule is clearly preferable. Think about contributory negligence. That was a majority rule, and if the ALI had waited about 10 years for its second restatement, it would have adopted the minority rule at that time of comparative fault because it is clearly preferable, as turned out to be the case by the end of the 20th century. Sometimes there is an emerging trend in the law, and restatements don't evolve. They are static for their lifetime. It's a shame, again, that the second restatement was in the mid-60s rather than in the 70s when the emerging trend toward comparative fault was adopted. And it wasn't until 2000 that the ALI got around to adopting a section on comparative fault. All of these considerations are built into a pithy statement about what the ALI should strive for in its restating by former director Herb Wexler. This statement was on the walls of the ALI conference room back when I started doing work on the restatement of torts, and it is one of the few things that I have committed to memory because of the guidance that it provides. The final element down here is something that Chris adverted to that's in the style manual for reporters. If you're not going to adopt the majority rule, be transparent about it. So on medical monitoring, as Jeff explains, there's a fair amount of variation in those that do and considerable confusion about what this tort is and its requisites. We thought this was a place where a group of torts experts and the ALI process could make a contribution for those courts that will confront this issue in the future. And that's what medical monitoring attempts to do, to draw the core of what's in the cases that have adopted it, to understand the courts that chose not to, and to try and create a coherent statement about medical monitoring. When it comes to vicarious liability for sexual assault, I think there's one important thing that Chris forgot to mention. When we dug into this subject and started doing research, we found 120 cases in which courts refused to dismiss or grant summary judgment to plaintiffs, victims of sexual assault, who were suing the employers of those who had assaulted them. Think police officers, think correctional officers, think nurses' aides, think teachers who have sexually abused victims in those settings, vulnerable victims in those settings. I'm going to take one more minute, Jeff is precedent.
I'll give you additional time.
We found a significant number of cases in the last 30 years where courts have been sympathetic to those claims for vicarious liability. And what we attempted to do was to take the core of what those courts did, they did it in a variety of ways, and have a coherent statement about employers of employees who sexually assault those able to do it because of their employment and who are given power that enables them to do the assault. We had extensive discussion about it at the annual meeting, and it passed by a significant majority of the membership of the ALI. And I'm very proud of that section.
Thank you, Professor. This segment of the program, we have a chance for the panelists to react to some of the conversation that we've heard. I'd like to give Larry the first shot at responding since he went first. And Chris did mention, here at Scalia Law School that Justice Scalia was critical of one of the ALI restatement products in an opinion. And I did a little research too, and similarly, Justice Thomas and Justice Alito have criticized some of the restatement work product, and basically along the lines that they're wading into policy rather than aggregating the majority views out there or the best views. Larry, what do you take of that criticism? And Jeff and Chris also had some pretty pointed criticisms of some of the current innovations. What do you think?
So anytime that you undertake a large project like a restatement, there's going to be somebody or some people who are going to be critical of the results. It's just not possible to please every person, every way, all the time. But you as a judge sitting on a case, confronted with an issue that is covered by a restatement, you don't have to rely upon what I say or Chris says or Geoffrey says. You can go to the restatement, and laid out in the restatement in comments to each black letter is the reasoning and the rationale for why that black letter provision has been provided. And that is followed by the reporter's notes, which lays out the authorities, often pro and con, on that point. So you can see the entire legal landscape right there in front of you in the restatement, and you can form your own opinion on whether it's valid or not. Now, Chris jumped on me for amending at the last minute the interpretation rules in the consumer contracts provision. But from my perspective, interpreting a contract against the drafter is standard old contracts interpretation law. And the fact that it hadn't been included in the consumer contracts, I was concerned that somebody might misinterpret that. And so I wanted it in that consumer contracts provision. And I made the motion, and it was debated, and it passed. And I expected it to pass. Now, you may or you may not agree with that rule, but you'll find that rule and its rationale and its case support in that consumer contract. And that's true of all of the other things. It's true of medical malpractice, medical monitoring. It's true of consumer assault. It's true of vicarious liability. It's all laid out. So you can form your own opinion about whether you think this is a valid thing. And I think that's one of the great services of the restatement, is you get to see the landscape, and then you can decide what you think is the better rule that should be applied. The fact that the ALI says that it happens to be the better rule doesn't mean that you have to follow that. You can disagree, but you'll understand why the ALI says it's a better rule, and then you can form your own opinion.
Yeah, I'll let Chris go next. I didn't attend the particular meeting that, and I wish I had been for that one.
There's a couple of points I actually want to respond to on that, because it speaks to, we're actually not in disagreement about certain aspects of it. I guess we get to some of the conclusions are differ, and maybe just one thing about disagreement in terms of process. Larry mentioned that his view of the consumer contracts project that I used as an example, that was a last-minute amendment, that was literally 15 minutes, and it was suddenly a black letter rule after 10 years. He said it was very much supported in the case. Well, the reporters of that project strongly objected to that rule because it didn't reflect existing law in their view, and they're the reporters who spent 10 years drafting it. And if you go back, and he said, if you go, it's stated in the comments and in reporters' notes. Well, no, it's not. If you go back and read the reporter's notes, it doesn't cite a single case for that proposition, not one. I went back and read it last night. If you look at the comments to it, this is a weird quirk of ALI, but we actually, as the organization, approved the black letter rule and didn't approve any comments because they hadn't been drafted yet. They were added later. So the ALI membership, this is a weird thing for them, but I've never seen it happen before, but we actually approved as a body, the ALI membership, approved a section of the ALI that was a restatement that was going to get added, but without comments, and the comments were just added later and never really vetted by the ALI. They were vetted in a smaller circle, but never by the membership. I think most members who supposedly approved the project never saw the comments or never said up or down, but they did approve Larry's motion. So I guess that's a disagreement, and that's, in my view, a process failure. Because the whole point, what gives the restatement's credibility is that the view that by judges in particular, that they are strenuously vetted. We heard comments about the process being so robust. Well, that's, in my view, was a process failure. And then that's just one of the points. Another one is that Larry pointed out that they have a black letter rule, you have comments explaining the rule, and then so everything's there, the judge can decide for him or herself whether or not he accepts it. One of the problems with that is that sometimes the comments explaining or elaborating the rule aren't that transparent about the support for the underlying rule. And that has the potential to confuse or mislead judges as to the state of existing law. And I find that to be a very significant problem. And that's one of the problems that I think Jeff was speaking to in the medical monitoring, that there's conflicting views. If you really wanted to take the majority rule on an issue, well, the majority rule on the issue would be no medical monitoring, period, full stop. But that's not what they did. And again, I don't have a problem whatsoever with the ALI adopting minority positions on any issue. I just want it to be, first of all, stated, hey, this is a minority rule, we think is the better rule, we're adopting it, versus, hey, there's some different rules out there, we're just gonna kind of amalgamate them in our own way and come up with a rule that when you look at it is actually an invention. It's a rule that doesn't exist anywhere. And I find that to be not what judges expect when they're viewing a restatement. So I'll stop with that.
Yeah, I guess Justice Alito was probably saying buyer beware with the restatement for the judges out there. Jeff?
Yeah, I feel many of the similar concerns. I guess I'll just say I come back to what are your assumptions when you come to the restatement. And I think for a lot of folks, including myself, until I sort of dug into some of what was going on in the third restatement, it was an assumption that this will be a very helpful resource that probably accurately restates what the majority position is on the law. And I think that's still true in a lot of cases, but when you get into underdeveloped areas of the law where there's a lot of disagreement, that is not what the restatement is. It is the reshapement. I mean, they're taking a position. You read the comments to the medical monitoring provision, it's a brief to a Supreme Court to adopt medical monitoring without present physical injury. That's what it is. The other side is not really presented except to say that it's wrong. So I don't think that that is serving the function of the restatement as I understood it to be. And I think that my understanding was justified. There was, in 2019, a note from the director of the ALI on this issue of what is the purpose of the restatement. And he wrote, the debate over the role of restatements is as old as the Institute itself. Sounds like, Jeff, you're late to the party. We've been doing this all along. That was a surprise to me, so I continued to read. He says, from the beginning, restatements were meant to be at once analytical, critical, and constructive. Their object should not only be to help make certain much that is now uncertain and to simplify unnecessary complexities, but also to promote those changes which will tend better to adapt the laws to the needs of life. That sounds surprisingly advocacy-oriented for what I thought was a project to restate the law as it exists. But then it goes on almost in the next sentence and says, it appears that the first round of restatements completed between 1923 and 1944 almost always restated majority legal rules. Well, that's how we got our assumption about what the restatement is actually doing most of the time. Because, in fact, historically, that has been the project of the restatement. We just find ourselves now, at least in the areas that we've been talking about this morning, with a project, an entirely different project. And that's my issue with it. I think what would be more helpful to me as a practitioner, and I think to judges who are trying to grapple with difficult emerging areas of the law, is to have a full discussion of both sides of the argument, an acknowledgement up front. We can't restate the law because there is no law to restate or no consensus of the law to restate. Instead, we'll tell you this jurisdiction does it this way, this jurisdiction does it another way, here's the arguments, you guys decide. And that's not what the medical monitoring restatement provision does.
We'll let Professor Green make a final comment, and I would be interested to hear if you think the ALI has evolved into more of a policy-making objective over the decades since the restatement second of torts. And while he's commenting, it's time for the audience participation Q&A. So if you want to ask a question, come on down to the microphones on either side, and I'll recognize you.
So I'd just say that restatements have, for quite a while, attempted to synthesize from cases and come up with a coherent synthesis of those cases. Prosser did that with the privacy torts in the second restatement. There was a disparate body of cases, such as Jeff described in medical monitoring, and he got them, extracted the core, and wrote 4 black letter provisions that protected interests and privacy. When Prosser, you've all heard of Section 402A, I hope?
I was going to ask about that.
I hope you've heard about it. It is the most cited provision the ALI has ever put out. It adopted strict products liability. Prosser didn't have a majority of case law when he did it. He had warranty cases, he had food product cases, and he had a California and New Jersey that supported him in imposing strict product liability. That rapidly got adopted by the vast majority of courts after the ALI published 402A. So I think I disagree with Jeff on the notion that restatements state majority principles. I don't think they ever have.
All right, let's turn to some questions. Start over here.
You stated that the standard for a restatement is that it has to set forth clear formulations of common law as it presently stands or might appropriately be stated by a court. My question is, are you relying solely on published opinions in that a number of us may have opined by way of a decision or an order about some area of law, but the decision is unpublished, which could lead me to believe that perhaps there is some existing body of law that would then result in a restatement if that decision were published. Now, I myself have not cited in any of my decisions to the restatement, but if there is a topic by which we may want you to comment on, perhaps that may be advisory that we should perhaps cite to it in some of our opinions so that it can become part of that body of law that you now consider. Can you talk about that?
I think that's a very good question. Unfortunately, we're limited in what we as reporters can access in terms of the law that's out there, and that's pretty much what's available in traditional legal sources. On occasion...
Mike, there have been occasions that the reporter's notes do include unpublished opinions. Typically, as I understand unpublished opinions, they're not novel, new issues of law. They're just an application of a well-recognized principle of law that doesn't warrant the publication process because that issue of law is so well established. So well, I don't think that the inability to access all unpublished opinions in any way detracts from the process of coming up with a restatement.
If I can piggyback off that, I agree that there are, if you look at the reporter's notes of lots of restatement provisions cite unpublished opinions, it really just depends, I think, on whether someone in the members' consultative group happened to learn of it and send it in, and that's typically how it gets published as opposed to it not being available on Westlaw or Lexis or something like that. I would say, though, that the ALI is actually, it's a variant, but there's at least one restatement provision that is based entirely on 2 dissenting opinions. So that's, it's in the restatement of the law liability insurance, which I had followed. So, and that was, the case law was pretty slim on the issue. There were 5 cases or something like that, and all of them went one way, and the ALI chose in this case, I objected because I'm not sure that is a minority decision, a minority view at that point, if it's literally just 2 dissenting opinions, because that's not even the majority rule in that case. So in any event, that's just for what it's worth. There is, I would say the ALI, to its credit, does do a good job of scouring the decisions that exist out there, oftentimes because if they are doing a more esoteric issue, they need to tap every resource they got.
Thank you.
Yeah, over here.
Thank you for this panel very much. My question is for Professor Green. You said sometimes an approach is clearly preferable, and then you commented, reflecting maybe 20/20 hindsight on comparative versus contributory negligence and the way the law eventually developed. And Mr. Stewart identified that all 3,000 members can comment on an approach. So my question is, preferable to whom?
Well, typically, it would begin with the reporters, right, who have that view, but then it would get vetted through the process. If it turns out that we're wrong in what we think is preferable, we find out. I just give you an example. We restated the firefighter rule. You remember that rule that governmental rescuers, they cannot make a claim against the negligent person that required the firefighter. We restated that. And we went to the annual meeting and found out that the membership disagreed. And a motion was made, and the Institute said, we want to repudiate our prior adoption of the firefighter rule because the membership decided that that was not appropriate.
And so when you say the membership, is it simple majority when things are close? How does the restatement deal with that?
It's not often that things are close, I can say. There are times. But, for example, the medical monitoring that you heard about and the sexual assault, those were passed by substantial, in the case of medical monitoring, an overwhelming majority, and for sexual assault by a substantial majority of the membership.
Thank you.
You know, I do have a follow-up to that response, because in the meetings I've attended where there's been the back and forth discussion, and you know, we're in a big ballroom at a hotel, and the people that are there really self-select into coming to a particular meeting, you know, the schedules, and you know, depending on the topic, you might generate more interest in attending a meeting or not. And yes, you're supposed to leave your clients at the door, but there's a lot of interest in, you know, both personal and policy preferences on how these things evolve. And so you really get a self-selected group that's going to be then voting in person out of, what, 4,000 people. Is that a flaw in the process where you really don't have the entire membership endorsing a particular position, but just a majority of those who attend a particular critical meeting?
Yeah, I think that's fair, though I will observe that depending upon when the session is scheduled, if it's on Monday morning, you have a lot more people there than if it's on Wednesday afternoon just before the meeting is going to end. Some of the Wednesday afternoon meetings.
So you can manipulate the audience even further.
But, you know, when you've got 300 or 400 or 500 people there, most of them are not invested in what it is. They're not lawyers who have acted on either side. Judges come with a neutral perspective. Academics often have their own views. But I think that you get in those several hundred people a sort of sense of where the bar, the bench and the bar are with regard to the issues that actually are controversial and need to be resolved.
Yeah. Chris, you have a reaction?
Yeah, so I mean, I agree in terms of, I find that funny, the Wednesday crowd does dip off a little bit. But the idea that many of the people there on, say, the beginning of the annual meeting, and that's when all the things are really done at the annual meeting. The main approvals, I should say, are done at the annual meeting for the membership. All happens one time a year, annual meeting, usually in DC. But the idea that you have a couple hundred people show up to the annual meeting, most of whom are not invested, I find that to be a process problem. You have a membership of, I think it may even be 4,500 ALI members when all is said and done, if you add all the ex officio and all that stuff. But so you have this kind of significant size group, a fraction of whom attend the annual meetings. I suppose many organizations are like that. But a small fraction attend the meetings, and a smaller fraction then attend the specific meeting of the project that they might have some interest in or at some level. But the fact that they come into, so many come into it not interested or invested or have followed the process is a real problem, because they can be swayed very quickly by what sounds like a good argument made on the floor of the annual meeting, and it can change the course of a project very quickly. As opposed to, I think that the ALI needs to invest more in having an engagement requirement of its membership. Like, most people put it on their resume and they say, yeah, I'm an ALI member, and that's all I'm going to do. But if you actually required engagement at some level, you would get people that are invested in the work product. You get a much more robust discussion, I think, and you would eliminate the possibility that someone strolls into a meeting and votes on something because, hey, that guy made a good point at the mic. But that's a problem if what that person made at the mic doesn't comport with the ALI's written standards for a restatement. It does something that's out of left field, and that you shouldn't have a situation where the course of a project that has been going on literally a decade can be skewed in that way. And that's, I find, so I agree, it's, you can look at it as a strength or a weakness, and I guess in this case, I look at that as a weakness.
Yeah, we have time for a final comment. I'll turn it over to Larry, and if you could also tell the audience how they can become a member of the American Law Institute.
So first, the self-selection criticism doesn't take into account the fact that all of this material is continuously published on the website. So all the drafts are on the website, all the comments that are sent in are on the website that every member can access and see. And when what the self-selection criticism doesn't take into account is that members have actually read this material ahead of time and decided that they're comfortable in agreement with what is being proposed and don't need to show up to say something about it. So I wouldn't put too much credence in the idea that because it's only part of the membership that's there, that somehow detracts from the validity of this process that goes on for all of these different steps and involves and has the opportunity to involve all of these people at various different levels. As far as becoming a member of the organization is concerned, you have to be nominated. You can't just sign up. This is not something where you send in a $5 check and you get a plaque to put on your wall. You have to be nominated. There is a vetting process that you go through, and not everybody that's nominated gets approved. Their qualifications for leadership, their qualifications for scholarship, their qualifications for being invested in the process of law reform are all looked at And it's only after that process goes on that it then is recommended that they be approved for membership, and then that's voted on by the council. And ultimately goes to the membership to approve.
I think all of you would find it rewarding to be a member of the ALI, and if you're interested, I'm sure there's a member in your community that could perhaps nominate you.
Let me just offer, I mentioned that the third restatement has superseded much in the second restatement, but it's a little hard to find that. If you find yourself with the second restatement of torts and wondering about the third restatement of torts, have your law clerk call me or email me. I'm on the Washington University in St. Louis website, and I'd be happy to help with locating where the third restatement has addressed something that was in the second restatement. By the time the third restatement is finally published, there will be a chart that will show what sections in the second restatement are in the third restatement. That's not available yet. I'm happy to help.
Please help me in thanking this panel.